Assalamu alaikum and welcome to Just Law on IQRA TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, on Just Law we normally discuss an area of law which is of interest to you, our viewers. Secondly, and more importantly, Just Law is a live show. So whatever questions you've got on any aspect of the law, you can pick up the phone and give us a ring, and hopefully I should be able to give you some guidance in relation to your queries. Now, on this show, we should be able to cover most aspects of English law, matters ranging from immigration matters, family matters, personal injury matters, whatever your questions are. Hopefully, we should be able to give you some guidance in relation to that. Just a couple of points before we get going. As always, because it's a live show, obviously we're not able to look at your documents before we advise you live on air. Now, if it transpires from your phone call that I do need to look at your documents before I can advise you, then I will ask you to leave your number with the control room and I will give you a ring back later on, and we can arrange for your documents to be sent to me for me to have a more thorough discussion with you after I have seen your documents. Secondly, obviously because it's a live show, it's not possible to take very detailed information from you. Now again, if it transpires that I do need to speak to you and get a lot of detailed background information, again I'll ask you to leave your number with the control room and I will then have a more thorough discussion with you off air. Having said that, in my experience, the vast majority of questions that we get live on air, we're able to provide you with firm advice, firm steer, firm guidance in relation to the matters that you call about. Sometimes it may well be that all you need is a second opinion. That's not a problem. You may have a lawyer who's dealing with your case already. It's normal human nature to say, you know what, I just want somebody else's opinion just to satisfy myself that the advice that I have been given is correct. It's not a problem. You can give us a ring and we can have a discussion about what's going on with your case. On this show, we get a lot of questions on immigration matters, which is fantastic. And bearing in mind a lot of questions do relate to immigration matters, I do tend to pick a topic relating to immigration law on this show. So what I tend to do is go through that topic in a bit of detail. And these topics are normally topics relating to which we get a lot of questions live on air. So it's the area which is quite topical, which is of concern to our viewers, and they're the kind of topics that we normally cover. What I want to do today is to look at the issue about those people who have overstayed in the United Kingdom. People who have been here maybe for a short time, maybe for many years. But the common theme between these kind of people here is that they don't have legal stay in the United Kingdom. They might have initially got some kind of visa to come to the UK, they might have had legal residence in the UK, but for whatever's happened, there's now a problem with their immigration status. On the other hand, you have those categories of people who have come into the UK illegally. So from the outset, they've not had any real legal status to be in the United Kingdom. What I want to do is to look at what can be done for those people to try and regularize their stay in the United Kingdom. What options are available for them? So generally speaking, what we tend to do is to look at an individual's circumstances to see whether on their own, based on their length of residence, based on their own circumstances specific to them, whether there's anything that we can do. Then if we look at whether based on any relationships that they have, any partners that they have, if they have children, etc., whether on the basis of wider relationships that they have, whether we can do anything to try and regularize their stay in the United Kingdom. So that's what I want to look at in depth today on this show. The position of those who have overstayed, who are living in the UK, want to try and do something to become legal in the UK. I want to look at the options open to them. This is an important topic, not only because obviously for anybody who's overstayed, it's something which is very close to their heart. They're very keen to try and sort their position out. Not only because of that, but because it's unfortunate, but there are many people who are misguided or they misunderstand what options are open to them. And what I find in practice is that people tend to make a lot of hopeless applications, and hopeless applications which are completely unnecessary, which only result in them losing a lot of money, paying fees to the Home Office, and if they've got advisors, paying fees to advisors. In my experience, it's not normally proper lawyers that they're dealing with. It could be that they've fallen into the hands of unregulated advisors who advise them to make applications which have absolutely no merit and have no chance whatsoever of being successful. And all that happens is that those people who apply end up losing money, and they end up worse than the situation that they were in before. So for those reasons, this is quite an important subject, and I want to look at that in greater detail. Although we're looking at the position of overstayers today, whatever your questions relate to, whether it's to do with overstayers who are trying to regularize their stay, or whether it's another immigration related query or any other matter, please do pick up the phone and give us a ring, and hopefully we'll try and give you some advice in relation to that. Now, as I said, let's look at the issue of those people who have overstayed in the United Kingdom. Let's deal with it by looking at whether someone who is here as a single person, who doesn't have a relationship, marriage, that doesn't apply to them. They don't have any children at all. So the person who has overstayed is someone who's been living here maybe for a number of years, but the particular circumstances that they are in is that they are here on their own. There is no one who they are the dependent of, and they don't have any dependents on their own. Unfortunately, what you tend to find is that those people are in the most difficult situation. They have to apply to regularize their stay in the United Kingdom simply based on their length of residence. That's the key thing for somebody who is here as a single person without any relationships, and they've overstayed their visa in the United Kingdom, or they've been staying here without a visa from the outset. Their opportunity to regularize their stay in the United Kingdom depends simply on their length of residence. Now, the position is actually quite clear-cut as far as the Home Office is concerned. A single person over the age of 25 has to have lived in the UK for 20 years before they will be eligible to be granted some kind of legal residence in the United Kingdom. Now, there used to be a rule which said that if somebody lived in the UK for 14 years, a part of that might have been legal residence, part of that might have been a period when the person's overstayed, or it could have been 14 years of complete overstayed in the United Kingdom. But there used to be a rule up until 2012, which basically stipulated that anybody who's lived here for 14 years would qualify for indefinite leave to remain in the United Kingdom after 14 years of residence, whether it's legal residence or whether it's residence where someone had no legal right to live in here. But after 14 years, they would qualify for indefinite leave to remain. It's unfortunate, but in 2012, the Conservative Party, when it reformed the immigration rules, and there was a huge upheaval in the immigration rules, one of the things that they introduced was the removal of the 14-year rule and an introduction of a different rule for those who have overstayed in the United Kingdom, basically changing the position from being able to qualify for indefinite leave after 14 years to being able to qualify for indefinite leave after 20 years of residence, whether it's made up of legal or unlawful residence. So there was a significant change from 14 years to 20 years. Now, we get asked this on a regular basis that, look, when I was in the UK, at that stage, the law said that 14 years of unlawful residence meant that you still qualified for indefinite leave. Does that still apply? We'll look at that after we've taken the next call. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum.
Ji walaikum salam. Ji bhai.
Can I ask a question to you?
Yeah, of course you can. Yeah, you're live on air.
Oh, you're live.
Yeah,
Oh, perfect.
Yeah, fire away.
Sorry, I just want to ask you something. Basically, I have a British passport now.
Okay.
And obviously, my mother, who lives in Pakistan.
Okay.
She's widowed.
Okay.
And obviously, she's 65. Few years ago, I did apply a visa for her.
Okay.
Like for a visiting visa.
Okay.
Visit visa, sorry. And obviously, I showed as a hotel, as a booking and stuff.
Okay.
So what are the chances for her if I want to apply for her indefinite and some sort of stuff?
So you know when
Do I have any chances?
You know when you applied for a visit visa before, was she granted a visit visa? Did she manage to
No, she was refused because she didn't have the strong ground.
All right, okay.
Or that they had a doubt that she's not going to go back. To be honest, at that time, my intention wasn't that she's going to stay here.
Yeah.
But obviously, she's there by herself now in a sense. Like, I mean, I've got my brother there, but he doesn't live in the same city.
I understand.
So she lived there by her own. So I'm a bit worried for her as well.
Okay. There is a route to settlement for parents, but the difficulty is the conditions which need to be satisfied are quite onerous. So somebody who is a parent who is abroad and isn't able to look after himself or herself can potentially apply to come here on a permanent basis. But the requirements that need to be satisfied in reality are very, very difficult to satisfy. Because what they talk about is, look, she has to be your mother, which is fine, that's the easy bit. She must need personal care. So potentially the person has to be sort of disabled or bedbound, so has to have the need for personal care. Then it says that there must be nobody within your family in the home country who's able to provide that care. So the first difficulty you have is if you've got brothers or sisters there, they say, well, they should be able to provide that care. So even if you get over that hurdle, what they then say is that, okay, you've got no family members there who are able to look after your mother, but if there is a system there within the country whereby personal care can be provided, like you have in the UK where the local authority has a system for carers coming in and providing care. Well, they say if you're from a country where that level of care can be provided, then again, there's no need for that person to be coming to the UK on a permanent basis. So although in answer to your question, there is a rule which says they can apply for settlement, the reality is those conditions are very, very difficult to satisfy. That must need personal care. There can't be anybody from your family who's available there to look after her. Even if there's nobody within your family, there has to be no organization, no public body that provides that level of care. Now, what they tend to do is if you make that application, they say, okay, even if your family is not able to look after her, there are these organizations. So they go on Google, they work out care. There's nursing care available in Pakistan. There's this kind of care available. So then they say, look, these are all the organizations which are able to provide care to your mother. So because of that, we're not prepared to grant her a visa. It's very, very difficult, to be quite honest. I mean, all you can do is try for a visit visa again. You know, and it's your luck whether the visit visa is granted or not.
Granted or not. Okay.
Okay,
so that's the only option I have technically.
Unfortunately, yes. That's
okay, all right then. But Jazakallah for
no problem.
Really
No problem. Jazakallah. Thank you very much for your call. Right, so just going back to the position of somebody who is single and has overstayed, the position unfortunately now is that they must have been living in the UK for 20 years before they are able to apply for legal residence. Now the big difference when you compare the position now to what it was in 2012 when the law changed is that the length of residence has changed. Before 14 years was sufficient, now you have to have lived in the UK for 20 years, so the length of residence has changed. The second huge difference is this, that previously, once an application was made after living in the UK for 14 years, the applicant would become eligible for indefinite leave straight away. Now the difficulty is after 20 years of unlawful residence, when an application is made and is successful, the person only is granted a 2.5-year visa. And the way the scheme works is that it's a 2.5-year discretionary leave which is granted to them, and the applicant, the person who's overstayed and who manages to get a visa, is expected to apply for an extension every 2.5 years. So the first 2.5 years is completed, an extension application is made. After that, we get to the 5-year mark, another extension application is made, so on, so on, so on, until the person has completed 10 years of legal residence in the United Kingdom. And it's only at that stage that the person becomes eligible to apply for indefinite leave to remain. So there's a huge difference from what it was before. 14 years and then you become eligible for indefinite leave to remain. Now it's spent 20 years in the UK, unlawful residence or mixed lawful and unlawful residence, and then when you apply, all you will get is a 2.5-year visa. You will have to continue to extend that until you reach the 10-year mark, 10 years of lawful residence, and it's at that stage you will qualify for indefinite leave. So there's been a significant change. The other problem that one experiences in this area is that when you apply on the basis that you have been living in the UK for 20 years, what they want is proof that you've been living in the UK for 20 years. Now that's a huge problem, because generally those people who have overstayed tend not to have formal documents which they can rely on. If they worked, they've normally worked illegally. So there isn't a record with HMRC of their employment over the last 20 years. They may not have even joined a GP practice until much later on. They might have come here in their 20s, healthy and well, not really wanting to go to the doctor. And therefore, they don't have medical records which go back 20 years. So now we're in 2018, we're trying to gather documents not from 2008, but from 1998. You're trying to show residence from 1998 to 2018, and you're trying to get these documents together. You don't have any employment documents which go far that back. You don't have medical records. You don't have dental records. So it does cause a great difficulty for somebody who's trying to prove that they have been in the UK for 20 years, albeit the residence was unlawful. So that's the hurdle that somebody faces. One is getting to that 20-year mark. And even after getting to that 20-year mark, how do you prove that you've been here for 20 years? What you tend to do in practice is to then start looking at alternative evidence. So you don't have these formal documentary pieces of evidence. You may not have bills. You may not have tenancy agreements. What do you then do? Well, you're stuck at that situation, so you look at alternatives. One of the alternatives is that you may have friends and family in the United Kingdom. They might be able to confirm that you've been living in the UK for the last 20 years. You may have photographs which go back over a period of time. You know, you might have attended weddings, people's birthdays, etc. So you might have a series of photographs which show that you've been here for the last 20 years. You've got evidence of friends and family. You might have photographs. There may be certain organizations, there may be religious organizations, mosques, madrasas, whatever organization that you're affiliated with. Those organizations may be prepared to give you some kind of reference, some kind of document confirming that yes, this person has been here for so many years. We've known him he or her. They've been coming to or taking part in activities here, etc. So you end up having to collate that kind of evidence to try and show that you've been here for 20 years. But all in all, where a person is single, they don't have a partner, they don't have children, it is actually still very difficult for them to obtain indefinite leave or some kind of legal residence. Now, what I tend to find in practice, and I just want to deal with this before we move on to the more common situation where somebody who's overstayed, now they've got married or they've got children. Just focusing still on the person who is single and who's overstayed. What I tend to find is that out of desperation, they obviously see many lawyers or advisors, and there's always somebody, maybe it's an unregulated advisor, there's always somebody who'll say, look, you know what, put an application in, let's make some kind of human rights application, and we will be able to try and get you some kind of leave to remain. The reality is that it is extremely difficult, and I would say in 99% of cases, or even higher of cases where somebody has overstayed, hasn't been living in the UK for 20 years. The reality is whatever application is made, that application will be refused. Let's take our next call. Hello, अस्सलाम वालेकुम.
जी वालेकुम अस्सलाम.
जी आपका जी क्वेश्चन क्या है?
जी वो मैंने पूछना था कि मेरी शादी हुई है इधर यूके में.
जी ठीक है.
तो मैं यूके से सॉरी लंदन से बात कर रही हूँ. तो मैं विजिट वीजे पर इधर आई थी यूके में.
जी ओके.
तो मेरा नाम हलीमा सादी है और मेरी उसके बाद तकरीबन 10 साल के बाद तकरीबन 8-9 साल के बाद मेरी शादी ब्रिटिश बोर्न के साथ हुई है.
जी ठीक है.
तो फिर हम लोगों ने वीज़ा जमा कराया है तकरीबन शादी के 2 साल के बाद.
जी ओके.
तो फिर उन्होंने बोला कि हमने खुद ही अपनी लाइक 1-1.5 साल के बाद हमने इंग्लिश वेडिंग की है. तो उन्होंने मेरा पहले वीज़ा जो है रिजेक्ट कर दिया था.
जी ठीक है.
तो मेरे हस्बैंड जो ब्रिटिश गैस में काम करते हैं. तो फिर हम लोगों ने इंग्लिश वेडिंग भी हो गई है लेकिन अभी तक कोई वो मुझे एवरी 4 वीक के बाद मुझे वो बुलाते हैं उधर सिर्फ बुलाते हैं. तो फिर वो मुझे पता कुछ भी नहीं कराते, ना फिंगरप्रिंट लेते हैं ना साइन लेते हैं, कुछ भी नहीं. फिर बुला के तो फिर मुझे वापस नेक्स्ट 4 वीक की डेट दे देते हैं.
ओके चलो ठीक है. तो आपकी वो सिविल मैरिज तो हो गई, इंग्लिश मैरिज हो गई ना?
जी वो जब हमारी बड़ी थी ना जी तब हुई थी. तो अभी तक उन्होंने कोई जवाब नहीं दिया क्यों ऐसा लेट कर रहे हैं.
ऑलराइट ओके. और आपके यहाँ 10 साल हो गए यूके में?
जी मुझे 10 साल. मैं अंडर एज आई थी.
अंडर एज आए थे. ओके. तो आपका अभी एज क्या है आपकी? ओवर 25 है?
जी नहीं मैं 25 की एग्जैक्ट. 25
के. और कितने साल हुए यूके में आपके?
मैं 2007 में आई थी.
2007 में. so 70.
मेरे कोई फिंगरप्रिंट नहीं थे आने से पहले. कोई कुछ भी नहीं था.
तो उसने ये किया आपको कहा कि हम होम ऑफिस ने ये कहा आपको कि वो ट्रैवल डॉक्यूमेंट बनाएंगे, आपको पासपोर्ट ऑफिस वाले लोग आपसे बात करेंगे, ऐसा कुछ किया आपके साथ?
नहीं कुछ भी नहीं कहा. सिर्फ उन्होंने मुझे उधर काउंसिल में डाल दिया वो ईटन हाउस में कि आप एवरी 4 वीक इधर आओ और वो
रिपोर्टिंग में जाओ.
फिर उन्होंने बोला कि आप अपनी वापस एप्लीकेशन डालो. मेरे सॉलिसिटर ने वापस एप्लीकेशन डाली है लाइक नियरली 2 मंथ जुलाई में डाली थी.
ठीक है. आपके कोई चिल्ड्रन है?
नहीं उन्होंने ये भी पूछा था कि आपके पास बच्चे हैं. तो अभी अल्लाह ताला की मर्जी, अल्लाह ने नहीं दिए.
जी. सो आप अभी हस्बैंड के साथ राइट?
जी अल्हम्दुलिल्लाह. कुछ भी लाइक अल्हम्दुलिल्लाह हम दोनों एक दूसरे के साथ हैप्पी है. कोई उधर ऐसी बात नहीं है.
जी ठीक है. जेन्युइन है. ऑलराइट. असल में आपका सिचुएशन ये है कि ये लोग होम ऑफिस की जो सिस्टम अभी ये है कि जब बच्चे हो जाते हैं तब वीज़ा दे देते हैं. सो आपने एप्लीकेशन तो डाल दिया है और वो एप्लीकेशन में उसको डिसीजन देने में 8-9 मंथ्स हो जाएंगे. सो अगर 2 मंथ्स हो गए तो और उसको 6-7 मंथ्स लगेंगे आपका एप्लीकेशन देखना और जवाब देने में. सो टोटल रफली अबाउट 9 मंथ्स के बाद अभी वो जवाब दे रहे हैं ये एप्लीकेशंस के लिए. मगर
पहले उन्होंने बोला था हम आपको 6 मंथ या 3 मंथ में जवाब देंगे.
नहीं वो नहीं देंगे. वो रफली अभी चल रहा है ये जो आपने जो एप्लीकेशन डाला है ना ओवरस्टे का शादी पे, रफली अबाउट 9 मंथ्स अभी लग रहे हैं उसके जवाब देने में. पहले काफ़ी ज़्यादा डिले भी था. पहले 1.5 years भी लगाते थे मगर अभी एट द मोमेंट द प्रोसेसिंग टाइम अबाउट 9 मंथ्स है. मगर असल में प्रॉब्लम ये है कि बच्चे के बगैर वो वीज़ा नहीं देते. ये प्रॉब्लम है. तो आपने अप्लाई किया ठीक है, आप देखो कि क्या होता है. मगर जब आप अगर प्रेग्नेंट हो जाएंगे ना तो आपके पास मच स्ट्रॉन्गर केस होगा. तो इंशाल्लाह वी जस्ट नीड टू टेक अ शॉर्ट ब्रेक. विल बी बैक इन द नेक्स्ट फ्यू मिनट्स.